Good afternoon or good evening to all our
It's
participants joining in
3:30.
from abroad. I'm Janada Pereira and I'll be your moderator for the day. Today in this workshop, we will be delving into the intricacies of coexistence agreements and IP arbitration, which is imperative to understanding this year's mood problem. We are happy to have with us today two eminent resource persons to walk you through these areas of law. Ladies and gentlemen, moving on to the first session of the day, we have with us Professor Naazima Kamardeen. Let me introduce Professor Naazima. Professor Naazima is the chair of the Department of Commercial Law at the Faculty of Law of the University of Colombo. Professor Naazima holds a Doctor of Philosophy degree from the University of Colombo, Sri Lanka, a Masters of Law degree in International Legal Studies from Georgetown University of USA, where she studies as a Fulbright scholar, and a Bachelor of Laws degree from the University of Colombo, Sri Lanka. She is also an attorney at law of the Supreme Court of Sri Lanka. Currently, she teaches international investment, intellectual property and tax law at undergraduate level, and international trade, cultural and intellectual property at postgraduate level. She is also a member of the Law Commission of Sri Lanka. She has also authored two books titled Global Trade and Sri Lanka, Which Way Forward, which was published in 2016, and Biopiracy's Forgotten Victims, Lessons from Sri Lanka, which was published in 2019. Professor, we are delighted to have you here with us today. Before I hand over the session to Professor Naazima, I have a small notice to our participants. Please have your camera switched on throughout the session and your mics muted. If you have any questions throughout the session, feel free to drop them in the chat so that we can attend to it in the Q&A session. Without further ado, let me hand over the session to Professor Naazima. Professor, over to you.
Thank you very much, and good day to all of you from wherever you are joining. I would also like to echo the request that if you can keep your cameras on, that would be very good, so that we can make the session as interactive as possible. And in any place where you don't understand or you have a query, you can always stop me and ask, because sometimes if you wait until the end of the session, you may proceed with a lot of confusion, and that would be a good thing. Since we have some international participants, I would first like to confirm that all of you come from countries that have already acceded to the WTO. Am I right? Right. If there's anything to the contrary, please let me know. You can post in the chat box or let me know. Why that is important is that if your country or the Harmonized Customs Union to which your country belongs has become a member of the WTO, then it is obliged to follow all the provisions of the TRIPS agreement. And I don't think we can have any fundamental understanding of coexistence agreements until and unless we are settled on that point. The presence of TRIPS can manifest in two ways. Either you may have had a domestic law tailor-made to conform to the provisions of TRIPS, which is what Sri Lanka has done in terms of its IP Act 36 of 2003. Alternatively, some countries may choose to proceed without a law, but are obliged to give effect to the provisions of the TRIPS agreement in some other way. But the traditional route has always been that a country would either amend its existing IP law or enact a new law altogether to bring in these provisions. That's fine. Now, in our university, at least in Colombo, IP law is only an elective in the final year. So I would first like to know how many of you are learning IP law because of this Moot. All of you? Yes, that's quite okay. Right? Let me check. That's right. So this happens to a lot of students who do Moots, right? Especially if it's to do with international law, international humanitarian law, or IP law, or investment law. What happens is, long before you learn it in law school, you're forced to study it for the purpose of doing a Moot, and you're forced to study great parts of it in great detail. For example, coexistence agreements. We don't sometimes even teach it in our IP survey course because it's only a very small part of trademarks, and there has to be some pre-learning attached to it. So what I generally do when I also help students with Moots for other purposes, if it is to do with IP law, I try to give a background to the particular subject area, and then give you an idea about what is this and where did it come from, so that then you can do the rest of the learning by yourself. So I want to give you some sort of a background into what coexistence agreements are, but there are at least 1 or 2 steps we need to take prior to that. You may have already studied those since you were getting ready for this Moot for some time. And I also will not be too specific on the domestic provisions, because I am aware of the fact that we have students from other jurisdictions as well. But generally, most of the provisions, so I won't go, by subsection, but most of the provisions are fairly similar. So that should give you some sort of an understanding. And then we will get on to what coexistence agreements are. What is their function? How do they come about? Where does the dispute arise? And we'll talk a little bit about it in relation to your Moot problem as well, right? If that is okay, then give me a minute. I am trying to look for the tab. Yeah, could you see this? Could you see the screen?
Yes.
Yeah, I think I need to go back to the beginning. No, it went off, right?
Not yet, Professor. We can still see the slides.
You can still see it?
Yes.
Yeah. Can you see this, the first slide now, where I've just said coexistence agreements?
Yes.
Okay, fine. So I'm just going to do it like this so that I have an idea of how many slides we have left, an idea of the time. I won't blow it up to full screen. So this would be our discussion outline, and I'll straight away get on to the topic. The first thing we want to look at is the definition of the trademark. I'm sure you may have already seen this, but this is what TRIPS tells us. TRIPS says that a trademark could be any sign or a combination of signs which is capable of distinguishing the goods or services of one undertaking from those of another undertaking. So the first thing you want to do when you are looking at this definition is you want to see what is at issue. I believe this kryptonite is for, one is for software and the other one is for hardware, right? In your Moot problem? Yes? Okay, in which case it is, you'll have to first identify, is it for a good or is it for a service? Okay, that's the first thing you need to do. Such signs including personal names, letters, fictional names, all of that. So then that's the next thing you want to see, what sort of a trademark is kryptonite. Then the last one, members may require as a condition of registration that signs be visually perceptible. Okay, so what did the TRIPS agreement do? The WTO did not impose visibility as a condition, because non-visible signs are what we also call non-traditional ones, like sound and smell and touch and things like that, are not registrable in all countries, right? But TRIPS wants to be applicable to all countries. That is why this is left as an option. So this is the Sri Lankan Act, and those of you who come from other jurisdictions, you can refer your own act. In Sri Lanka, we have the word here, visible sign. So we have made visibility, because the TRIPS agreement allowed us that flexibility, we have made visibility an important requirement of the trademark, because that was permitted by the TRIPS agreement. That means what we call non-traditional trademarks cannot be registered in Sri Lanka, because their representation is graphical. So either a hologram or a diagram or some other way is done. This is also subject to some sort of debate, but it is not relevant to you, because luckily you don't have to deal with a non-traditional trademark. Okay, so I don't need to go into that any further. Then there are two grounds for inadmissibility of a trademark, which means if you have a trademark for a particular, let us say, product, and you take it to your intellectual property office or your trademarks office, they will examine it on two different criteria altogether. The first one is called the objective ground for inadmissibility. That means where the trademark is looked at by itself, right, on its own merits. And for some reason, the trademark will be declared inadmissible because there's a flaw in the mark on its own merits. That means the trademark itself has a weakness. Okay? And can any of you tell me what some of those weaknesses might be? Even if you don't look at the act, because I don't want to go by the domestic act only. Right? In all of your jurisdictions, you will not allow the trademark which is the shape or the form imposed by the good. So you won't allow a screwdriver shaped trademark to market screwdrivers, right? In any one of your jurisdictions, you will not allow a descriptive trademark, right? Which would say what is the quality, what is the quantity, what is the intended purpose, right? So you will never have something like instant tea, right? That's the purpose of it, for instant tea. Then in any of your jurisdictions, right, if the sign or indication has become a generic name for the product or the service, that is in each of your countries, if the average consumer associates a particular word. Now for a long time, the word cell was associated with mobile phones, and originally there was a company called Celltel in Sri Lanka. Do any of you remember it? Yes or no? Now I can't see the screen because I can only see my PowerPoint.
Yes.
Do any of you remember? Yes? Yeah?
Yes, yeah.
Exactly. And it went out of business. Why? Because everybody thought that they didn't think that Celltel was a brand. They thought Celltel is the name of the product, which means however much marketing Celltel did, they couldn't have sold their products. People would have gone and bought another kind of product instead. So a generic name cannot be a trademark. Then things like a single number, a letter, grammatical sign, unless it has acquired great distinctiveness, those are also not allowed because they are not distinctive, right? But that's why it has to be a combination of letters and symbols and so on. Then if it is contrary to public policy or morality or things like that, it's a scandalous thing, that also won't be allowed. Then a misleading trademark will also not be allowed, right? That means if you mislead, if you have a brand called Fresh Milk, but you're selling powdered milk, it will not be allowed because it is misleading the consumer, right? Then, while people can always use their names and surnames, it has to be represented in a special or particular manner. So, Times New Roman, black font, you won't be able to get a trademark. You have to represent it in some other font, in some other color, because otherwise, if you have a very common surname in Sri Lanka, like say Pereira or Silva or Jayasinghe or something, and you go and trademark that, nobody else can use their names. And then we have had this huge issue about geographical names and surnames. I am not going to go into it because thankfully you don't have that issue to deal with, and that problem is very complex, at least in the Sri Lankan context. So I'm not going to go into the geographical name issue. Then there are other grounds, right? So even if you have a very nice trademark, if the product you're going to market with it is illegal, you won't get the trademark, right? Then you can't use the trademarks that are associated or very close to what states or the international organizations that are very well known will do, and definitely for the logo or official signs of the state, so you can't use that, right? So, and there is a catch-all phrase, at least in the Domestic Act, saying anything else that may be prescribed. So there are a number of reasons for which your trademark may be denied admissibility just by looking at the trademark itself. They are called objective grounds, right? So I went through it just in a few minutes, but were you aware of this before today's workshop? Yes? Yes, you were aware of objective grounds before today's workshop? It's okay if you weren't, right? Then maybe we can, maybe the other speaker will talk about it, but you can also then get some help on looking at it, because it's very important for you to know how a trademark is first given and where a trademark is denied. Well, that's important for coexistence agreements, okay? But because I'm not covering that section, I just went very fast through it, okay? Then the second thing, now let's say the trademark passes on the objective grounds, right? It's not a descriptive trademark, it's not a generic trademark, it's not a misleading trademark, all of that is fine. Then still it will be subject to the second layer of scrutiny, and that is called inadmissibility based on third-party rights, okay? Based on third-party rights, which means because a trademark deals with the market, it's not something you're getting in isolation to go and sit in the forest and, you know, meditate over. We also have to see, the trademark examiner has also got to see what is the status of this trademark vis-a-vis other trademarks that are operating within this market. So trademarks are very much concerned and tied up with a market. That is why trademark registration takes place every 10 years, and trademarks can be removed if there is no use, right? There is no point in the trademark examiner giving you a name that you're going to monopolize if you're not actually using it in the market. So that is why it is very important that the second layer of scrutiny be done. And now this is very important for you also, right? So in Sri Lanka, it's in section 104. And for those of you foreign participants, it would probably be right next to this provision on objective grounds. So what do these grounds do? They compare the trademark with already registered trademarks and declare that the trademark is inadmissible for registration, either because it is identical to the product or similar to the product, or identical mark or similar mark. So you can have 4 possible combinations. You can have an identical mark and an identical product, in which case, without any examination, they will deny the mark, okay? That is there in section 121, subsection 4. Just make a note of it. If you bring an identical mark for an identical product, the examiner is not even going to look at it, because they're going to presume the likelihood of confusion, right? And it will immediately be knocked out. But you can have an identical mark for a similar product, a similar mark for an identical product, and a similar mark for a similar product. So where one of the variables has the word similar, then there will be an examination done to see. The main test is, will this new trademark that we are going to register cause the public to be confused and misled, right? That is all that the trademark examiner is interested in. Whether this element of similarity and sometimes an element of identicality will mislead consumers, because that is the primary function of the trademark, to avoid misleading consumers. So therefore, what will the trademark examiner be most concerned about when looking at the new trademark? Because they have already registered the existing trademark. Then they want to make sure the new trademark that is coming in is not going to be identical or similar in any way concerning the product or concerning the mark, so as to mislead consumers. And that would be the primary objective of measuring this trademark that has now come up, right? So in the local act, it says, the Director General shall not register a mark which resembles in such a way as to be likely to mislead the public. A mark already validly filed or registered or someone that is filed by a person validly claiming priority in respect of identical or similar goods or services in connection with which the use of such mark may be likely to mislead the public. Okay, so that is that. Then the last thing that I want to discuss with you is the concept of the well-known mark, right? Now, you know there are some marks that are so well-known that everybody knows them, right? Even if you go into a village in a remote area and you say Coca-Cola, a lot of people will know it. Isn't that right? There are brands like that. There are trademarks like that. Now, well-known marks are dealt with in our Act at least, section 104, subsection D. What I want to tell you about a well-known mark is that even if a well-known mark is not registered, now usually trademark doesn't consider anything that is not registered. It has very limited rights, an unregistered trademark. But if the trademark is well-known, it gets some respect, even if it is not registered, right? And a new trademark seeks to come in, and it is either identical in some way or similar in some way, registration will not be given for identical products, right? Registration may be given for products that are not very identical or not very similar, provided that no one is going to connect this new product with the well-known product, and the well-known product's reputation would not be diluted. But if the well-known mark is registered, then no other product can be registered. So if Coca-Cola is well-known as a beverage, but it is registered, you cannot even register Coca-Cola erasers, right? But if the mark is not well-known and it was registered, you could register another product category. You know that, right? You know that, right? So if the mark is an ordinary mark and it's registered, I mean, let's say you have Alpha staplers or something, you can have Alpha towels. That's okay. But if the mark is well-known and registered, it precludes every other product category. And I'm sure this provision is there in all your laws. Okay. Now, why did I take so much time to talk about that? Because it is relevant for the next one, the coexistence agreement. Now, you probably already know this definition because you are doing a Moot that is heavily based on this. Now, a coexistence agreement is a contract. You must remember that. A contract made by two parties to use a similar trademark for marketing purposes without interfering in each other's enterprises. Okay. Now, before we go there, I want to mention this to you. When you apply for the trademark, with whom are you dealing? Who can tell me? When you apply for the trademark, with who are you dealing? With the trademark office. Yes? Yeah, you're dealing with the regulator. In a coexistence agreement, with whom are you dealing?
With another party who's in the same business?
Exactly. You are having a contract like any other sales or any other purchase contract. It's a contract between two parties, right? Breachable, enforceable, so on and so forth, right? So that is a fundamental aspect of the coexistence agreement that you must understand. While you went and registered your trademark and you got undertakings from a government regulator, when you sign a coexistence agreement, you are only having a contract with another party, right? That's the first thing to remember. Then, now we come to really the crux of the issue with coexistence agreements. Okay. Now we saw that in every country, you have a heavy screening process at two levels. First, the trademark is checked on its objective grounds. As a trademark, is it strong? Secondly, it was checked on subjective grounds. Is it going to clash with another trademark that is validly already there? Then, how is it possible that two similar trademarks could be in existence at the same time? Which means, what is the rationale for a coexistence agreement? Okay. Now, can any one of you tell me the answer to that question? We have already seen. Yes, tell me.
I would assume that, like in this case with the Moot, that you have different jurisdictions and different issues in those respects. I suppose that one trademark office in South Africa or Sri Lanka wouldn't assess something in India or whatever it may be. So you have two different jurisdictions with two different trademarks are allowed. So when the companies want to branch out, then it becomes an issue in the other jurisdiction where that other trademark is allowed or was registered rather.
Yeah, thank you, Liam. That's a perfectly good answer, right? This sort of issue generally may not arise if you're inside the same domestic jurisdiction, because then you'd have a centralized trademark office, you'd have a trademarks register, and it would have failed on subjective grounds on the third party rights. The issue with coexistence agreements is one, geographical reach, which means you can have trademark A registered in one country, trademark B registered in another country, and then when they want to spread to another geographical area, they find that they are going to have a problem. They're going to clash. The second area that this can happen in is when the product itself starts enjoying a wider reach. So you want to branch out into maybe newer products under something like a trade name. So that is the reason why this problem arises. So the coexistence agreement is a solution to a problem, right? You must understand that. To know that, you must know what was the problem. Okay, Liam explained it and I endorsed it. So now I want you to think back to your Moot problem and look at how did this arise? How did kryptonite with a K, which was for the hardware, right? And kryptonite with a C, which was for the software. How did both of them grow beyond the original parameters? And where did they begin to clash? Okay, that is the first thing you need to find out. Then we would see at that point where these two companies realize they are going to clash in some way, they quickly created a coexistence agreement. Okay. So this is now repetitive. The reach of the two trademarks begin to overlap each other, right? Since they are given for particular products or services or categories or geographical regions, they may originally be confined to these but start expanding due to popularity. And it is in the expansion that the overlap manifests. Now, the rest of this presentation I have taken from a note that I got off a WIPO website. It explains this, and since you need it at a basic level, I have given you the reference and I have also given you the text. So this is how it starts off. It says trademarks are used by small businesses with a limited geographical area or blah, blah, blah. Then none of this will lead to conflict or litigation as long as the trademark will perform its basic function, which is to distinguish the goods or services from those of competitors. Then what happens? If this distinguishing function no longer works because the businesses for which the trademarks were originally used begin to overlap, or the geographical area begins to overlap, right? Now, this is frustrating where both businesses use their identical trademark in good faith. Now, where one person is mala fide, you can always say, yes, that person is trying to encroach or infringe, that's okay. But where both of them are in good faith, like the two parties in your compromise, in your problem, right? Then you have this issue. They will each start having their legitimate expectations about expanding their trademark and have a legitimate frustration when they find that somebody else is using the trademark, right? So that is when the coexistence agreement will come, where two companies are aware that they are using a similar identical marks. They choose to go in for this. And we can see the coexistence agreement also is a sign of good faith, where instead of going in for litigation, the two companies try to resolve this in some sort of an amicable way, where they say, okay, we understand that this is going to become a problem because our trademarks are either identical or similar. And we want to make sure that we can both operate in this market that we're going to be, So that is also a sign that both parties are in good faith, right? So this is some of the reasons for coexistence agreements, where you may not have cast your net wide enough when you were looking to register a trademark in the first place. But for your purposes, that is not relevant because you're already in the problem, right? I mean, if you were a trademark lawyer, you might advise a client, look even globally. Now, don't just look at your domestic trademark register, look globally and see whether there are other brands and stay away from them, because it's going to be a problem for you later. But here in this case, that issue has already, is water under the bridge. Okay. So that just in some common law jurisdictions, the concept of honest concurrent use may apply, right? So you also need to see, can you use any of these arguments in your moot, right? Do you have this concept of an honest concurrent use? In some jurisdictions, they do allow that. Where there are lots of traders operating with unregistered trademarks, sometimes the concept of honest concurrent use is given so that the prior owner of the trademark or the prior user of the trademark, even if it is they have not registered the trademark, will not be asked to stop using that mark. So you will find in some jurisdictions, this concept of honest concurrent use is there, where two people, perhaps in good faith, and one is previous in time, but the previous in time does not register the trademark. Then the person later in time seeks to register the trademark, but because of the prior use, the person with the unregistered trademark is also allowed to operate, right? So that may be one point that you can look to see whether it is applicable in this case. So then we look at what can coexistence agreements do, okay? So the first thing to understand is both parties recognize the right of the other to their respective mark. Now, this is a major victory when you consider, I mean, a litigious perspective. Because in the litigious perspective, you don't want to consider the other person's trademark. You say, it is my trademark that prevails and this other person is now trying to encroach my territory. The coexistence agreement acknowledges from the beginning, you have a registered trademark, a valid one. I also have a registered and valid trademark for these things. Then what happens? The coexistence agreement will agree on the terms on which they may exist together in the marketplace. Now, when this happens, it may be that an older or the older of the two or the more popular of the two trademark may have to diminish itself a little. I mean, there's always a give and take. So you may have this position where you have to subjugate some of your rights in order to get something else. So there's an element of give and take, which is probably why this is there in your moot, because you will be arguing for both sides, right? And at that point, you will have to see where is the giving and then where is the taking. What am I giving up in return for something else? What is the other party having to sacrifice in order to gain something? And how could we optimize what we gain, all right? Such coexistence may be based on a division of the territories in which each holder may operate. Now, that is a very important point for you, because I think, according to your moot problem, the issue is about registering in a territory, right? In a new territory where the other party hasn't gone in yet, but they are apparently well known in that region. That is why you also need to check out well-known trademarks, okay? Because they also have a separate level of respect attached to them, okay? Now we are very interested, right? You are well known in two territories. You already have a coexistence agreement. Now you want to go elsewhere. And in the elsewhere, it is an issue because then either neither party is registered or one party is well known, okay? And I think that is the issue that you are having in your moot. So the coexistence agreement can also be a delimitation of their respective fields of use, that is regarding the goods and services on which they are used. Now there's a point to be noted there as well. When you get into the coexistence agreement, you may only be operating in 2 or 3 product areas. So it's important to know, are we going to add a few more product areas when we get into this coexistence agreement? Otherwise, we may be getting stuck, or we may be operating in a limited area, right? So that is something, again, you have to check when you look at the documents that you got for the Moot. Okay, now I'm going to give you a case study. Yeah, can you tell me where the chat box is, or where I can post some content?
Professor, when you go to your meeting window, on the bottom right, there is a small message icon, sort of icon.
All right, yeah, okay, fine. You can read the whole thing, right, if you go down?
No, Professor. It finishes after excluded.
Exclusive.
Exclusive, yeah. There's he only
Okay,
have a
then what
part
I'll
to
do
that.
is I think I will stop sharing it and then just show you that screen. Okay, so I'll stop presenting. Yeah, could you see it now?
Yes, Professor, we can see the Word document.
Yeah, okay.
Yes.
You can see the entire thing?
It starts from coexistence agreement, and at the end we have a link.
Now?
Yes, yes, Professor. The top
Yeah, you
bit
can
is,
see it?
yes.
Yeah. Okay, so I'll give you a couple of minutes to read this. Right, I'll just paste the link also so that you can go to it and you would be able to access that entire thing and read it a little bit more at leisure. Okay, I will now get back to the presentation, the last few slides. So you will see there that the two companies had a coexistence agreement. They had clearly defined products. Yes, Liam, you have a question.
Sorry, Prof. I just wanted to ask. So, generally, as a point of departure in IP law, is the point of view always from the consumer?
Yes.
Or do the courts take different angles when they're looking at these types of issues?
No. Generally, when it is trademark, it is looked at from the point of view of the consumer. Is the consumer going to be misleadingly confused?
Okay.
Or misled or confused or misleadingly confused, right? That would be the base, the benchmark for how a court would look at, regardless of whether did these people have rights. So if you're enforcing the coexistence agreement, that's why I said it's a contract. Then the rights enforced are the rights agreed in the contract, because that is between the two parties. Right? The coexistence agreement is between the two parties. Then it is looked at from the party's point of view and where is the breach and where are the entitlements. But even in spite of having a coexistence agreement, when you have other issues, which you do have in your Moot, because the issue is not really the coexistence agreement, the issue is now wanting to go to another geography. When you have a dispute, yes, what the court will look at is what is the potential effect on a consumer, because ultimately the function of the trademark, wherever it is to help the consumer to distinguish the goods and services of one company from the other. And whatever the rights you want to have, they will be subject to that basic requirement. Right? That is why I asked you to carefully consider the fact that the trademark is between you and the regulator. And whenever the regulator is involved, it is the consumer interest that is at heart. But the coexistence agreement is between you and another party just like you. It's a contract. And there, yes, the contractual rights and obligations what will prevail. So thank you for that question. That was a very good question. And it, I think, helped us to look at a little bit of at this with
Sorry, Prof. And then just a follow-up question quickly. Sorry to interrupt. So
okay.
then, when you're dealing
in the case
with
summary, I want to look at where the over. Yes, when we are dealing with the.
Sorry, Prof. I just want
Sorry.
also so when you're dealing with coexistence agreements and then IP law as well. So when the issue might be also what's in the agreement, and then also if it's a matter of IP law and trademark, what then is there a law that then trumps the other one or not? If you understand my question.
Yes, because the specific will overrule the general. The coexistence agreement has to be given priority.
Okay. Perfect.
Right?
Okay, thank you,
because
Prof.
It's a specific agreement between the two parties. Okay. Subject to that, after that, if you have other issues, then and the regulator has to decide or the court has to decide, then they will look at the basic principles. But the general principle is because the specific will override the general, the coexistence agreement will be operative unless there is something illegal within it. Right? I mean, unless it fails on another contractual ground. Right? But remember, it is a contract between two parties, and it is the one to which both parties have given their minds very well to. Because when you get a trademark from the regulator, you don't have a lot of bargaining power. You submit it, and then they'll give you the trademark or not. But in a contract, that is where there's a meeting of minds. You are supposed to have equal bargaining power. You expressly agree to those terms. So that is what will take precedence. If you have a coexistence agreement as between the two parties, that's between the two parties. But where the regulator or a court, an adjudicator gets involved, right? And if they have to also balance the interests of the consumer, there they will look at the fact of whether the consumer was misled or confused by whatever is going on. Okay.
Yes, thank you, Prof.
All right, I think I'm almost hitting 4:15, and this has kind of got a bit stuck. Let me go back to the. Right, you see this, right? So that would be one of the implications for the parties. The coexistence agreement will change the dynamic of the relationship from being solely with the regulator to one with a potential fellow competitor. So then in the coexistence agreement, you don't need an intervention by the state's trademark authority, right? Some strange thing is happening and it's becoming difficult to right, this is the last slide. Okay, so I also want to relate this to what you're going to do, okay? So what I would like you to do now that you have some background on this is to identify the facts of your moot problem in relation to the coexistence agreements, right? How did it come about? What did the parties agree? What was the original subject matter? Was it based on geographical reach? Then describe exactly in which manner the overlap occurred, right? Was it only geographical reach or was it product and service expansion, etc.? So you'll be clear about that. And then you analyze how did that lead to the conflict? Because there's a okay. And what existence the dispute, which means is there something they didn't consider originally? And what aspects also may be used to resolve it through the coexistence agreements. Otherwise, you have come to the coexistence agreement cannot offer us any advice in solving these things. Then we have to look for other ways of doing it. Okay, so that's my time, I think, is up. So I'm going to stop there. But the only advice I can give you is if you are not very well versed in objective and subjective grounds for trademark, I would advise you to go back and study that module a little bit more, maybe with someone who has already done the subject of trademarks, and then look at coexistence agreements to get more clarity on the topic, because coexistence agreement is something sophisticated. It goes beyond the reach of ordinary a trademark. So it's important for you to have a little bit of that background knowledge. Once you do that, I think it should be very easy for you to, deconstruct this moot problem. So I would like to wish all of you the very best in this very interesting moot topic. If you have any more questions, I'm happy to take them, but I'm aware that we have another speaker. So I'm going to ask the organizers to kind of advise us on that. Or you can always email the questions and I can answer.
Yes. Thank you very much, Professor Naazima. That was a very informative session about coexistence agreements and trademarks. I'm pretty sure all our participants had a lot to learn from your session. Yes, Professor, like you very correctly mentioned, we do have time constraints, but we can take about 1 or 2 questions. So if there are any questions from the participants, we can go ahead with the questions.
Sure.
To all the
if you have a burning question, you can quickly ask me.
Yes.
That is why I said to ask during the presentation so that you don't forget. But those questions were also very informative. They're very good. I think it helped us to iron out those difficulties. So if you don't have any questions, then we can wrap up. And if you do think of a question later, you can always ask the organizers to drop me an email and I'll be happy to answer it. All right? Thank you.
Thank you very much, Professor. Yes. All right. Now we can move on to the second session for the day. And we have our second speaker with us here today, Mr. Keshan Thalgahagoda. Let me introduce Mr. Keshan. Ladies and gentlemen, Mr. Keshan Thalgahagoda is an attorney at law of the Supreme Court of Sri Lanka, counting almost 25 years in practice, primarily in the areas of corporate, commercial, and intellectual property law. He is a founder partner of the firm Aequitas Legal, and he holds a master's degree in international trade law from the University of Wales. Before I hand over to Mr. Keshan, again a slight reminder to our participants, have your cameras switched on and your mics muted. And again, if you have questions, you can certainly drop them in the chat box. Without further ado, I will be handing over the session to Mr. Keshan. Mr. Keshan, over to you.
Hi, everybody. Can you hear me? Can everybody hear me?
Yes, Mr. Keshan, you're audible.
Right. Okay, great. So it's actually a pleasure to be speaking to all of you. I've had the opportunity of just going through the Moot problem. The topic that has been given to me is challenges faced in protecting trademarks in the digital age. So I'm not really sure about how it relates directly with the Moot problem, but certainly from the perspective of the Moot problem, if you do have any queries that you would like to throw at me, please go ahead. Don't hesitate. You're free to interrupt me as well. No problem at all. So I'm not sure. I just came in towards the latter part of Professor Kamardeen's presentation. So I'm not really sure about what the areas that she covered. But let me just start by giving a brief introduction to trademarks in the sense as to what is a trademark. I'm sure you know it, but just for purposes of completeness, I see a question. I see a post here about PowerPoint. I don't have a PowerPoint. I'm just speaking to you, just having a casual conversation with you. So just feel free to unmute yourself and ask any questions that you want. So a trademark, as you know, is some kind of indication, whether it is a logo, a name, a device, a shape, something that is capable of distinguishing one enterprise's goods and services from another. Now that is pretty straightforward. When it comes to registration of trademarks, there are certain criteria. I heard Professor Kamardeen mention this at the end of her presentation about the objective and subjective grounds on which regulators either refuse or accept for registration trademarks. Now, if you look at the objective grounds on which registration of trademarks can be objected to, that is basically when you talk about, for example, the theory is that you can't claim exclusivity, you can't register a trademark that is descriptive. You can't register a trademark that is somebody's name. You can't register a trademark that is a place. Right? So those are some of the objective grounds on which you can object or you can resist the registration of a trademark. But I think more importantly for you, what you need to consider is the subjective grounds. That is where the registration of a trademark, where an application for the registration of a trademark is presented, and that application, the new trademark that is sought to be registered, resembles an already existing registered trademark, or it resembles an unregistered trademark in respect of the same category of goods, or it resembles in a way that is likely to confuse a well-known international mark. Right now, just to digress there for a minute, I'm sure you, Professor Kamardeen, may have touched on this. Trademarks, like all aspects of intellectual property, are territorial in their application, in the sense that the registration of a trademark in one country will not necessarily give you protection in another country. So your intellectual property rights associated with that trademark is location specific. Now there are certain international conventions like the Paris Convention and the Madrid Protocol, which deals with protecting trademarks across borders, but the application of that convention and the protocol doesn't actually obviate the necessity of registering your trademark in a different jurisdiction. So, but having said that, there is this concept of unfair competition, the concept of passing off, etc., which is taken into account when a regulator, when an intellectual property regulator is called upon to consider an application for the registration of a trademark. So now, if the trademark that is presented for registration resembles an already registered trademark or resembles a internationally well-known mark, even if that mark is not registered in that jurisdiction, the regulator will take cognizance of that mark and refuse registration. Now, for that to happen, especially when it's an international mark, now if it is a mark that is, if it's an unregistered mark that is presented, if the mark that is cited is an unregistered mark in the same jurisdiction, what matters is how much or the extent to which that mark is used in that jurisdiction. When it comes to an international mark, that is a mark that is registered in another jurisdiction, you have to establish that person, the person who's objecting to registration, the owner of that international mark, has to establish that the mark is well known, right? Well known in the jurisdiction in question. Right? So the fact that the mark may not be actually used in that jurisdiction is not an issue. What matters is whether the mark is well known or not. And in the digital age, I think it's it's nobody lives in isolation. So a mark in relation to products or services that is used in relation to products or services across borders, and you can establish the fact that it is well known, you can certainly object to an application made to register a similar mark even in a jurisdiction where that well-known mark is not registered. Are you with me so far? Anything that you would like to throw at me at this stage? Yeah? Okay. So the concept of well-known marks and the concept of the subjective grounds on which registration can be refused is something that you might want to read up in a little more detail for the purposes of your Moot problem, because I think essentially those are the issues that you will have to deal with, apart from issues arising under the coexistence agreement. Now, having said that, let me just quickly move on to some of the main challenges that are faced by trademark owners in the digital era. Now, one of the obvious issues that arise is monitoring and enforcement. And the fact that, unlike in the physical sphere, there are no clearly defined boundaries. So you may have a registered trademark, say in Sri Lanka, and your mark may be infringed online, that is either on social media or on a website or on an e-commerce site, whatever. Your mark may be infringed by a person who is not in Sri Lanka. So then what happens? So you have a jurisdictional issue. So first of all, monitoring the entire internet to see whether your trademark is being infringed is very difficult. Secondly, even if you are able to identify infringements, locating the infringer is very difficult, especially in the online space where infringing parties, I mean, you only have IP address. You may not have an address. You may not have a name of the party who is actually behind the infringement. So all of these things pose problems. And even if you can identify the infringing party, then the next issue is, where is that infringing party based? Can we then enforce our intellectual property rights in that jurisdiction? Because trying to enforce your intellectual property rights in the jurisdiction where you have registered your mark will be of no avail, because that will the court in your jurisdiction. So the example of Sri Lanka, the court in Sri Lanka will have no power or authority to enforce or declare an infringement by a party residing outside the territorial limits of Sri Lanka. So these are one of the main issues when it comes to online, protecting your trademark online, monitoring the
It's 4:30.
infringements, and enforcing your trademark rights. Now, a lot of parties, to overcome this issue, what they do is they retain the services, for example, of monitoring agencies, so third parties who monitor the online spaces to see whether your mark is being used and bring it to your notice. Then once it is brought to your notice, you have certain remedies that you can then invoke, or certain provisions that you can trigger. Another way of doing this is to essentially, now, if the infringement takes place over social media, for example, say it's YouTube or Facebook or Instagram or whatever it is, these platforms, the more reliable and the more well-known platforms, have stringent rules when it comes to IP violation, right? So the first thing you can do is, if there is an IP violation, what you can do is immediately write to the platform and get them, establish your right, and get them to remove the offending or infringing posts. Now, there was a case in the US against YouTube. Viacom International versus YouTube, where Viacom International sued YouTube on the basis that YouTube had, there were videos put up on YouTube that infringed Viacom's copyrights. So the court didn't find YouTube liable because YouTube had taken immediate steps to remove the offending content from the platform. So it's called a safe harbor, the safe harbor principles. The host of the social media platform itself will, according to American law at least, the decided authorities in America at least, the social media platform will not be liable for infringement, not be liable for IP violations, provided it has taken sufficient steps to remove offending posts. That's why it's very difficult to put copyright violating music and videos on YouTube, because it's immediately flagged and it immediately gets taken down, right? So monitoring infringement through third-party agencies, using the platform mechanisms themselves to remove offending content. Those are some of the steps that trademark owners can take to ensure that their marks don't get violated and they are not stuck with a situation where they have to go and institute legal action in a jurisdiction that they are not familiar with, right? So, of course, the safest way to protect your trademark is to register your trademark in a jurisdiction in which which you plan to use your trademark, or a jurisdiction where your trademark is visible, right? So that is, obviously, this is a cost. It's a costly affair, right? But that is the safest thing you can do to get your. I mean, for example, if you are an exporter of goods or services, the obvious thing you would do is register your trademark in the countries to which your products or services are exported. Right? So those are things that you need to do. Now, for example, in the Madrid Protocol was introduced. It's a protocol that is administered by WIPO, which allows one application made in a country, a single application, a single fee, to obtain registration of that mark in multiple countries which are party to the Madrid Protocol. So as long as the countries in which you want to protect your mark are members of the Madrid Protocol, a single application is going to allow you registration in those countries, right? So, any questions so far? Nothing? Right. Okay. So I'm just going through this very quickly. I mean, obviously, there's a lot of content if we are really to get into it, but just skimming over the surface to give you some kind of pointers that might be of assistance to you in your mood problem. So please, I'm just going through it quickly, but please feel free to stop me if you want to ask me anything. So a few specific areas in which trademark issues may arise in the digital space. One obvious area is when it comes to e-commerce, right? You have websites like Amazon and eBay and Best Buy. These websites sell products put by different sellers, so they don't necessarily, the platform doesn't have control over the products that are sold through the platform. So this poses a huge problem. I know we have this problem in Sri Lanka as well. A lot of our online sales platforms, they sell counterfeit goods. Clearly goods that infringe registered trademarks, that infringe well-known trademarks. So when a trademark owner, brand owner finds this out, they go against, sometimes it's difficult to go against the merchant, so you go against the platform, right? So then the platform has an obligation, depending on what jurisdiction the platform comes under, and also a responsible platform will have good terms of use, where they will agree to remove any listing which infringes third-party intellectual property. So e-commerce websites are an area online where this trademark infringement takes place very, very regularly. Another area is domain registration. Now, have you heard of cyber squatting? Have you heard of the concept called cyber squatting? So cyber squatting is basically where, now let's say apple.com is a well-known domain of the Apple Corporation. Now let's assume that the Apple trademark is not registered in Sri Lanka, right? So somebody goes and registers a domain, apple.lk. LK is the Sri Lanka domain registry. So Apple, a third party, goes and registers a domain in Sri Lanka called apple.lk. Now, domains, unlike trademarks, while it is linked to intellectual property and can be an aspect of trademark infringement, anybody can register a domain as long as that domain is available. So if the apple.lk domain is available in Sri Lanka, somebody can go and register that. Now, that obviously is that is called cyber squatting. So what the intention of that party is to get that domain and basically sell it to Apple. So you basically register a domain with a name of a well-known company, and then you basically negotiate to sell that domain to that company. So that's called cyber squatting. It was a huge problem in the early days of the internet. Not so much now, because people can make use of trademark law to take action against us. So registering a domain which uses somebody else's trademark is a trademark infringement, although you are entitled to register a domain because the domain was available, right? So issues with regard to domains are problematic. So when merchants register domains, when they pick domains, again, they must always think about the link that domain has to their brand, link that domain has to their trademark, because all of these things are interconnected, right? And it also can pose problems if your domain is similar to somebody else's trademark or brand name, right? So that is another area where issues can arise. Another area which has posed problems is yeah, just give me a second. Yes. The use of targeted advertising through search engines. So what happens is merchants are able to bid for specific words. right? Bid for specific words on Google or any search engine, which means that if a surfer or a user of the internet types in that particular word, they are immediately directed to the person, the website of the person who bought that word, who bid for that word. Now, people use this, merchants use this to direct traffic to their website. So, for example, you this it happens in e-commerce a lot. So, you, for example, the word Apple itself, to use the same example, you type in the word Apple on a search engine. If somebody has bid for that word Apple and bought that word from Google or whatever it is, AdWord, it's called AdWord, has bought it, the website, the search results, have you seen on the search results, you get advertisement on top? So these search results are the people who have bought words. So it will be a company that is probably has nothing, absolutely nothing to do with Apple, but probably trying to benefit from the goodwill associated with the Apple name to direct traffic to its website. So that's another area in which the protecting brand names in the digital space becomes problematic, right? So there are various other with the advent of artificial intelligence, right? It's going to get even more difficult for merchants to protect their websites. Now, I was reading in that. I'm sorry, does somebody have a question? Can we mute that? Right. So now another area I was just reading up on this in the morning, where in the virtual space, that's the metaverse. You guys have heard about the metaverse, right? The virtual space. Gamers will be very familiar with this phrase. The metaverse is basically a virtual space where you can have your own avatars, and interestingly, you can actually make purchases of products, virtual products, in this space. Now, what happens is they are finding trademark infringement in this virtual space. So, for example, in a metaverse where you are able to go and buy your favorite sneaker, you can go and purchase a virtual Nike sneaker. Now, if this is not an official Nike branded sneaker, it becomes a problem. Basically, that virtual space, whoever is using that virtual space to sell this virtual Nike sneaker is technically infringing Nike's trademark. But then these are issues that have never probably come up for determination by a court, and to see whether such use of a trademark can actually constitute infringement of a trademark. Right? So there are many issues that can arise when it comes to protecting brands and trademarks in the virtual space. I don't want to go into too much detail, because when you do go into detail, you have to go into you have to get very technical as well. So I think that is beyond the scope of what you guys are looking for at this stage. So what I will do is I'll stop a little early, right, and give you all the opportunity to throw any questions that you want at me. And it doesn't have to be limited to what I spoke to you about. I know what I spoke to you about possibly doesn't have a lot of relevance to the Moot problem itself. So if there is anything that you would like to ask me regarding the Moot problem or generally about trademark law, please feel free to shoot it at me. And I'll try my best to, I'm aware that there are students from different countries online. So I'll try my best to answer it in a way that is universal.
So we have a question from one of our participants, Liam. Liam, you can direct the question.
Thank you very much. Thank you, sir, for your discussion and your talk. I just wanted to ask, taking back to kind of what you said in the beginning about, I think it had to do with well-known trademarks. And I just want to understand if I understood you correctly. So if we have an instance, let's say, for example, Coca-Cola that does not have any business in a certain area, let's say Sri Lanka or Zimbabwe or whatever it may be. But obviously the Coca-Cola brand might be all over the internet, and people in that country, the consumer, might know of the brand. So then, will Coca-Cola still be given preference in that instance?
Yes. That is the concept. That is the very basis of well-known marks. So essentially, though Coca-Cola may not even be sold in that jurisdiction, though Coca-Cola is not registered as a trademark in that jurisdiction, the fact that Coca-Cola is such a well-known mark will potentially be an impediment to anybody trying to register that mark in that jurisdiction. However, having said that, it happens. People will, especially if the brand has no presence, if the brand has no physical presence in that jurisdiction, and depending on the jurisdiction, a mark may be well known online, but in the physical space, it may not be so well known. So if the mark is not used physically in that jurisdiction, it may be open to a local competitor to come out with a product with a similar brand, a similar sounding name, a similar looking logo, and essentially the idea would be to try to appropriate the goodwill associated with the well-known mark. So it can happen, the use can happen, they can try to register their trademark in that locality, and because, for various reasons, the regulator may not flag it himself. So generally, when it comes to subjective grounds, that is where registration is refused due to third-party rights, it is not the regulator that intervenes. That is where where the importance of publication of the mark before registration comes into play. So any trademark in any jurisdiction, when you submit it for registration, if there are no objective grounds on which the mark can be refused, the regulator will publish the mark. So it happens in different ways. In Sri Lanka, it's published in the Gazette, and that is public knowledge. It's all over the internet. And if anyone, anywhere in the world, sees this mark and says, hey, that mark looks a lot like my well-known mark, they are free at that point of time to intervene, to object to the registration of the trademark. So the right holder, the third-party rights holder, has to proactively get involved in the registration process and object to the registration. At that stage, the regulator is going to hold an inquiry to ascertain the nature of the rights, to ascertain whether the mark is in fact a well-known mark, and basically, so in the modern context, with the internet being so pervasive and so accessible to everybody, it's very, very difficult now to register a trademark, a well-known mark, which is a mark that is well-known internationally. But it happens. It happens because, for the simple reason now, for example, a big corporate in the US may not be too concerned about a small country like Sri Lanka. So they won't invest in the necessarily monitoring mechanisms in Sri Lanka to keep track of applications that are presented for registration. So it can slip under the radar. So then if by chance a mark gets registered, so to use your example, the Coca-Cola example, if the mark gets registered, once it's registered, it becomes a bit difficult to get it struck off. So then generally what will happen is Coca-Cola will come, file suit, a settlement will be reached, the local party will be paid something, and they will assign that mark. So that is generally what happens. But essentially, when protecting trademarks, what is important is goodwill. That is, especially when it comes to unregistered mark, goodwill. Because the brand owner, the trademark owner, has invested considerably in building the goodwill of that mark. It is the goodwill that he wants protected, and it is that goodwill that gets diluted if you allow a third party to go and register it. I hope that answers your question.
Yeah, and then just following up from that, so obviously the centers around what is a well-known mark, obviously. So if it's not a well-known mark, then I suppose it becomes contentious, as opposed to like using it in different jurisdictions. So like things, I suppose, with Coca-Cola and Apple, that's relatively easy to say, okay, well, this is well-known. In your experience, how have the courts dealt with this concept of what is well-known?
Yeah, it's a very good question, yeah, and it's a problem that poses a lot of difficulty for trademark lawyers. So just to briefly talk about an ancillary problem you have now in a local jurisdiction. If you are trading or providing goods and services under an unregistered mark, and somebody in your jurisdiction goes and tries to register a similar trademark. Now your mark is unregistered. Somebody goes to tries to register register a trademark that is similar. Now you go and object at that stage. Now here the concept of well-known mark doesn't come in, but you have to establish user. So how do you establish user of that mark? You have to provide sales figures. You have to provide advertising proof, advertising expenditure. So when you talk about localities, you talk about sales figures, you talk about how widespread the goods and services are available in that locality, how visible the brand is, how much money is invested on advertising. So it would be similar principles that would be applicable to establish that a mark is well known. So well known in, for example, a mark that is well known in Australia may not necessarily be well known in another jurisdiction where that product is not available for sale. So establishing a well-known mark, it's basically, like you correctly said, unless it's a Amazon or Apple or Coca-Cola, one of these, Nike or whatever it is, a absolutely well-known brand. If it is a lesser known brand, it becomes obviously much more difficult to establish the fact that it is well known. So that is why it is always better if you potentially see yourself entering into a market to take all necessary steps to register your mark in that locality, in that jurisdiction.
Yeah.
Any other question?
To the participants, if you want to put your question in the chat, you have that option as well.
And like Professor Kamardeen said, I mean, if you don't want to raise your question here, please feel free to write in your questions to the organizers, and they can send it across to me. So whatever I tell you and whatever I can help you with is based on practice, the actual practice of trademark litigation and all, than the academic side of it. So even if it is with regard to the Moot problem itself, please feel free to drop me a question. Is the Moot problem itself clear to you all, and you have an idea about how to proceed with it? Good.
All right. Seeing as there are no other pending questions, like Mr. Thalgahagoda said, if there are any questions that you would like to direct to him, do make sure to email it to the organizers, and we will get it across to Mr. Thalgahagoda. Yes, thank you very much, sir, for that very insightful session. I'm pretty sure it had a lot for the participants to take. I'm pretty sure you added a lot to the knowledge of our participants today, and they will take this knowledge with them when they go for the Moot in August. Thank you very much, sir.
My pleasure. All the best to all of you.
Thank you, sir. Dear participants, I would like to request all of you to switch your cameras on so that we can take a screenshot before we end today's session. It won't take that long. It would be great if everybody could turn their cameras on. Yes, we will be taking the screenshot in 3, 2, 1. Yes. Thank you to all our participants for joining in today. I'm sure the 2 sessions were very insightful, very informative, and I'm sure that you had a lot to take home with you to your preparation for the Victor's Moot in August. And thank you once again for joining in. I know we have participants from joining from all around the world, whatever time it may be now at your in your country. Thank you so much for joining with us today, and I'm pretty sure that you learned a lot. Thank you so much, and see you soon. Have a wonderful rest of your day.
Thank you.